Hello everyone, welcome to Law Minds YouTube channel. Today we will learn about employment bonds and its legality in India. The first thing everyone should know is that the employment bond is certainly different from normal bonds. Normal bonds are issued for raising one's capital, while employment bond is a type of agreement related to work between the employee and the employer. Now let's begin with what are bond agreements. Bond agreement between the individual, it is a basic legal agreement between the parties upon agreeing on the terms and conditions of certain bonds. This bond guarantees the fulfillment of the contracts mentioned in the bond. Every terms and regulations and conditions should be fulfilled by both of the parties involved in this bond. The failure from any part of the parties of fulfilling the terms of the bond of agreement can lead to the aggrieved party of filing a suit in the court of law. The validity of a bond is attained when all the contract's term is agreed by both of the parties and that these bonds are entered by the parties with free consent, that is without any fraud, misrepresentation, undue influence or any such unlawful act which can lead a contract to be invalid. Next is, what is an employment bond? Employment bond is a type of bond that is issued between the employer and the employee to obligate the employee to work for the employer under the terms and conditions agreed by the employee. This bond also includes all the requirements of salary. The bond, which consists of a terms between the employer and the employee, can be called as employment bond, and this bond is signed between employee and employer. This bond also considers the consideration of his or her training cost. That means that the employer incurs all the expenses of an employee's training cost under this employment bond. As this bond is a legal agreement and contract, employment bond is hence governed by the Indian Contract Act 1872. It is a bond governed by Indian Contract Act. As this bond is a contract, it should abide by all the essentials that should have for acceptance and considerance with the parties signing the contract. Should do it without any undue influence or any misrepresentation, that is, it should be with free consent for that bond to have a legal validity, legal informants in front of the court of law. Employment bond ensures that no employee should leave the job before the stipulated time of the bond and that the employee should maintain the confidentiality within the organization. Now, the question arises that whether the employment bond is legal in India or not. Yes, the employment bond is legal in India as it is governed by our Indian Contract Act 1872, but this bond is subject to several restrictions and exceptions, and this bond should also abide by the essential features which is important to constitute a contract. This bond must be signed between the employer and the employee. It should be very clear and precise that both of the parties in the bond should understand the language of the bond. Also, that the employment bond should be entered through free consent, that it should not have any unlawful force upon any party signing this bond. The next is, how can the legal validity of an employment bond can be challenged? That is, how can an employment bond be challenged? Now, under section 27 of the Indian Contract Act 1872, the validity of the bond can be challenged as this section 27 invalidates any agreement which is in restraint of trade and profession. That means any term of a contract or of a bond which restrains any party of trade and profession, it in itself is invalid. This section also states that any agreement which is in restraint of trade and profession which directly or indirectly compels the employee to serve the employer or puts a restriction on them joining the competitor or another employee is not valid under the Indian law. Therefore, the employer should have the proof while entering the bond that every right of profession and trade was provided to the employee without any restrictions from the employer side, and that the employer has provided righteous training to the employee. The employee should have every freedom to trade and profession from the side of the employer, and that there should be no restraint or restriction from the side of the employer, and the employer should have a clear verification, clear document to prove that their side is clear of. The employer also has a right to demand injunction on the employee if the employer believes that the employee has joined forces with their competitors and it can risk their strategies to be opened with their competitor. And upon this, the court can restrict the employee's trade and profession as it can be harmful for the employer. Next is steps an organization can take when there is a breach of bond from the employee's side. There should be a legal notice sent to the employee who breached the contract stating the requirement of him or her returning to the work. Next step is when the employee fails to abide by the notice, the employer can ask for the compensation agreed in the contract for the breach of the said bond, and the employee is bound to return all the expenses incurred on the employer because of the employee. The employer must have all the reasonable proof regarding the breach of the employment bond. The employer for the claim of compensation of losses should have the reasonable proof stating the expenditure incurred to them. They should have a clear document so that it can be worked as a proof in front of the court of law. Let's begin with the leading cases related to the breach of an employment bond. First is Toshinal Brothers Private Limited versus Iswar Prasad, 1997. In this case, an employee working as a sale engineer was contracted for 3 years, but the employee breached the contract by only working for 14 months in the company. It was seen that no employer is obligated to show the post-breach damage and that the employee is bound for the compensation as a special favor was given to him by the employer because of the employment bond and by taking off the expenses of the training of the employee. The employer suffered from the legal injury and the employee should compensate. Next case is Fertilizers and Chemical Travancore Private Limited versus Ajay Kumar and others, 1990. In this case, the bond was signed between 3 employees for the training of 2 years and that they will serve a service of 5 years in the company. Due to the breach of the contract, the employee were asked to compensate rupees 10,000 even if the training was only for 5 months. The Kerala High Court stated that irrespective of the training period, there was still a loss of time, money and energy by the employer, and the company suffers a loss when the company employees leave the work. The employer was supposed to compensated by the employees. These were the cases that describes the breach of bond by the employees. I hope this video is helpful and that you understood everything about employment bonds. Thank you.